submitted their proposed jury instructions as well.
Yes, Your Honor.
And witnesses.
Yes.
They close, I have to finish my docket, but the jury should be here around 10 o'clock.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor.
Michigan versus Dominique Belafont, 25-03267. Appearance, please.
Anna Buckingham on behalf of the people.
For Dominique Belafont, she actually stepped out to use the restroom right before you took the bench, Your Honor.
On the record in the matter of State of Michigan versus Joshua Vogel, 25-02932. Appearance, please.
Anna Buckingham on behalf of the people.
Assistant Public Defender Jessica Straub on behalf of Mr. Vogel, who is standing to my right.
Mr. Vogel was scheduled today for final pretrial. This is for a domestic violence. Do we have witnesses here?
No, Your Honor, the people are unable to proceed without the necessary witness.
Counsel.
I assume defense will be making a motion.
We will, Your Honor. We motion to dismiss this case.
A motion is granted, is dismissed without prejudice. The people do have the right to reissue this charge against you, okay? Do you have any questions?
No.
We'll get you a dismissal in just a moment. You're all set. State of Michigan versus Rochelle Service, 26-00255. Appearance, please.
Anna Buckingham on behalf of the people.
Assistant Public Defender Joseph Bergen on behalf of Miss Service, who is not present.
Have you had communication?
No, her phone is either phone number is either wrong or it is cut off.
Oh, it's your thing.
Thanks.
State of Michigan versus Prentice Smith, 26-00174. Appearance, please.
Anna Buckingham on behalf of the people.
Assistant Public Defender Joseph Bergen on behalf of Mr. Smith is making his way to the podium.
Okay, Mr. Smith was scheduled today for final pretrial for domestic violence. The necessary witness present.
No, Your Honor.
Counsel.
Defense motion to dismiss.
Motion to dismiss is granted without prejudice. The people can reissue this against you. Do you understand that? Do you have any questions? We'll get you dismissal in a moment. You're all set. He's got to go back down to get his tether removed. He's untethered? Okay, we'll notify them so you can have your tether removed. State of Michigan versus Tracy Young, 26-00267. Appearance, please.
Anna Buckingham on behalf of the people.
May it please court, Daniel, on behalf of Mr. Young, who is approaching the front yard.
Mr. Young was scheduled today for assault and battery final pretrial. Witnesses present.
No, Your Honor, the people are unable to proceed without the necessary witness.
As such, Your Honor, we would ask for a dismissal, Your Honor.
Dismissal is granted without prejudice. You understand what that means at this point, correct? Okay, we'll get you a copy of the dismissal in just a moment. Any additional matters in the record?
Not from the people.
No, Your Honor, thank you.
Thank you. State of Michigan versus Tammy Bates, 26-00375. Appearance, please.
Anna Buckingham on behalf of the people.
Assistant Public Defender Jessica Straub on behalf of Ms. Tammy Bates, who is here remotely.
Ms. Tammy Bates is present from home on the Zoom, is that correct?
Yes, that is correct, Your Honor.
Okay. Ms. Bates, can you hear us?
Yes, ma'am.
Okay, today was the date that was scheduled for a pretrial. I have an assault and battery. There's also a contempt of court, PA 53 scheduled. How are we proceeding on this, Kyle?
Your Honor, people will be unable to proceed with the PA 53. We did send out a subpoena to the officer that we required to hold that hearing. Unfortunately, I have not heard. I have followed up and am unable to proceed without him.
Who is the officer?
The officer is Officer Roland Coulter.
Okay, and what's going on with the underlying matter?
With the underlying matter, Your Honor, I have not had a chance yet to speak with Ms. Straub about this matter this morning, but we will be offering jostling in this matter.
From the defense, Your Honor, we do have some competency concerns. We have therefore filled out the required paperwork. If I could have permission to approach.
You can, so you're not able to communicate immediately with your client?
There are some concerns.
Okay. Okay, so allegedly due to her past history of mental health concerns and her current condition, she's not meaningfully able to contribute. And so you're requesting the court to order her to undergo a psych eval. Any objection from the people?
No, Your Honor.
Psych evaluation will be granted. This matter will be scheduled for review date so that we can follow the status of the report from the Center for Forensic Psychiatry. And then we'll reset the PA 53 after that date and time. Ms. Bates, do you have any questions?
No,
Stay in contact with your attorney. Any additional matters for the record?
Not from the people.
Nothing further, Your Honor. Thank you.
Thank you. You're all set. I don't know who's NGL posted on.
am I done?
It's not. You're set. You're free to go.
Oh, thank you.
State of Michigan versus Jessica Cardenas, 25-02253. Appearance, please.
Anna Buckingham on behalf of the people.
Does she not have an attorney?
It looks like it's Mr. Kareem Johnson, Your Honor.
Yes. I'm just wondering that she had, I would hope, yeah. But he wasn't here on his last thing on Friday, did he leave?
Well, he of record, so he,
He filed an appearance.
but it's not changed in the system.
I think his
No.
substitution
He
was
did
hearing.
file a substitution, no one signed it, October 21st. And I was not here October 21st, so they should have had whoever was covering sign it. You have to reset Ms. Cardenas and notify her.
March 24th at 8:30.
March 24th at 8:30. You're all set, Ms. Cardenas. Take this to the clerk, tell them that they need to enter the substitution because I signed it. And then you make sure Mr. Kareem Johnson is notified of his court date. State of Michigan versus Austin Heffley, 26-00385. Appearance, please.
Anna Buckingham on behalf of the people.
Assistant Public Defender Joseph Hardy on behalf of Mr. Heffley. I checked with him. He told me that he is in the Zoom waiting room. I'm not sure.
He's in Zoom.
Okay.
Mr. Heffley, you need to start your video.
Okay.
Today was the date scheduled for a pretrial. This is for domestic violence. Has there been an offer extended?
No offer, Your Honor. At this time, the people are currently investigating contact between the defendant and the victim at his time in incarceration. We would expect a potential bond violation hearing upcoming. There is no offer to extend at this time.
Defense would just request a final free trial.
Well, What makes people think that there was potential contact?
Your Honor, we had another EPA looking into phone calls made from the jail. We currently have an investigator looking into this further.
So there were allegations, someone did listen to phone calls that they,
Yes.
okay, so then I can go ahead and arraign him on a bond violation. And have that said as well. So Mr. Heffley, there has been allegations that you violated the no contact order by having contact with the protected party, the alleged victim Josephine Rose Park or Parker, I'm not sure if they spelled it right. While, it says Park, while you were in the custody of the jail. And so if that is the truth, that you are facing a contempt of court, punishable by 93 days in jail and or up to $7,500 in fines. Do you understand that?
Yes, ma'am.
You have the right to have a contested hearing on that. The prosecution not only listens to the calls that they advise you are recorded from the jail, but if they believe there to be a violation, they will refer to a investigator to dig deeper into the nature of the conversation and provide a transcript of said conversation to the prosecution's office. So once that's provided, your attorney will get a copy of that, okay?
Yes, ma'am.
For the purposes of today, we're going to enter a not guilty plea for the bond violation. This matter will be set for both a PA 53 bond violation hearing and a final pretrial.
Final trial, April 7th at 8 a.m. Jury trial, May 5th.
Jury trial, May 5th. Okay, so your final pretrial is going to be April 7th, 8 o'clock in the morning. You have to appear in person. And then there's a jury trial, May 5th, 8 a.m. You also need to appear in person for that. You have any questions at this time?
No, ma'am.
Let me remind you of the bond conditions. You're not to have contact directly or indirectly with Josephine Rose Park. You're not to be within 2,000 feet of wherever she is. You are supposed to be on GPS tether with victim notification. You're not to travel outside the state. You're not to use, purchase, or possess a firearm, ammunition, or weapon of any kind, or to use or possess drugs or alcohol. All of those will continue. Do you understand that?
Yes, ma'am.
Do you have any questions about your bond condition?
No. No, ma'am.
Any additional matters for the record?
No, thank you, Your Honor.
No, Your Honor.
You're all set.
Do you need me any further?
You're all set.
Thank you.
You're welcome. I don't know who is so lazy that they're not whole punching stuff that's supposed to be in the file. They're just gonna leave it. So it's slide out. It's ridiculous. State of Michigan versus Isaiah Hollins. 26-00421, appearance, please.
Hannah Buckingham on behalf of the people.
Assistant Public Defender Joseph Hardy, on behalf of Mr. Holland, who is appearing via Howard.
Everybody has a bond violation these days. Okay, this is set for a pretrial, 2 counts of assault and battery. Looks like there's also a bond violation that he was remanded on. How are we proceeding?
Your Honor, it's my understanding that we'll be requesting to move to final pretrial. There is no offer to currently put on the record, and I also have the understanding that there will be a plea of guilty to the bond violation.
What prosecution I stated is correct. He would be admitted to at a bus station where the alleged victim is.
Final pretrial.
April 7th at 8 a.m. Jury trial, May 12th at 8 a.m.
Final pretrial is going to be scheduled April 7th at 8 a.m. in person at the court. Jury trial is going to be May 12th, 8 a.m. also in person at the court. And then he's pleading guilty to the violation of being at or where one of the protected parties lives, works, or goes to school, correct?
That is accurate, Your Honor.
Is that correct, Mr. Hollins?
Yes, ma'am.
Raise your right hand. Do you solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury?
I do.
Put your hand down. You have the right again to have a contested hearing on the violation and the right to have the prosecution establish beyond a reasonable doubt whether or not you violated your bond condition. Do you understand that?
Yes, ma'am. I was considered, oh, nothing.
Oh, you were what?
I showed up to the Caddis station because it was an inclement weather situation. I was just thinking to say, I didn't go there for personal endeavors. It was an inclement weather warming bus. It was a warming bus that I showed up because I stay outside. I'm homeless and my feet were wet and there was snow on the ground. So I didn't want to freeze, and there was a bus there that was for that situation. That's why I showed up. I didn't show up for anybody or personal business at all.
You were on a bus?
Yes, ma'am. It was labeled a special route bus, and it only showed up to warn people. And there was no security there that day. The business, it was not in hours. If it was not a warming bus, I would not have been on that bus.
Okay. No one's threatening you to plead guilty to this, correct?
Correct.
Okay, and you're pleading guilty because you believe you're guilty?
Yes, ma'am, because I was there.
Okay, and you understood that there was a bond condition, sir, that stated that you were not to be anywhere where Nathan Haas either lives, works, or goes to school, correct? No,
I
answer
was
that
not-
question. It's either yes or no.
Yes,
Okay, and you know Mr. Haas to be a security officer at the Caddis station, correct?
yes, ma'am.
But even though The court told you you couldn't go where he worked. You still went to where he worked. Correct?
I went there because the
Yes,
warning bus.
that's a yes or no. I didn't ask you why you went. It's a yes or no.
Yes, ma'am.
Okay. And so there are other warming centers in Lansing, are there not?
No, ma'am, there wasn't for me. No, ma'am, not
What
at
do you mean
that
it
time.
wasn't for you?
It was 5 a.m. and everything was shut down. And that
The
bus
city of
showed up for,
Lansing, the city of Lansing has issued a list of all the warming centers in Lansing. And the CATA is not the only one.
that's the only one that I had means of getting to. Like, I didn't even know that the CATA was doing that day. I was going by it and then it showed a special route just for warming. And I knew that it wasn't in business hours. So because it was an inclement weather situation, I thought that defeated, principality of the circumstance. And I
You
thought
don't
that
get
the
to
judge,
think about a bond condition. The bond said you're not to be within 2,000 feet of where he works. So you're not even allowed to walk past there to even see that there's a warming center. You're not allowed to walk past the CATA right now because that's where he works. And you know that's where he works. So you don't get to, I'm walking, listen, you don't get to, I'm walking by and it doesn't look like it's in business hours. So I'm going to decide in my mind that that defeats all principality of the situation so I can go inside. There are other warming centers across the city of Lansing that you could have went to that would not have violated your bond. And if you believe, I'm gonna accept your plea and find your plea to be freely, voluntarily, and intelligently made. But if you believe that you can unilaterally make a decision about when you can violate your bond conditions, then I am going to revoke your bond until this matter is handled, because you can't understand what personal recognizance means. It means I follow the order of the court, not that you get to decide when the order doesn't no longer apply.
no, ma'am, I wasn't trying to decide myself. I slept out.
That's what you did.
I was warning of health circumstances. I
Sir,
wasn't being.
you passed other warming centers
I know,
if you were
ma'am,
in that area.
No, I stayed 2 blocks. I stayed 2 blocks from the station. Like it's like a 500 yards or so.
I don't think that you get that you don't get to go by his job, because the allegation is that you have assaulted him and someone else.
I did not put my hands on anybody. I was pepper sprayed and left.
That's why I use the term allegation. You
Okay,
are not
yes,
allowed to go there.
I'll stay away. I did not mean to be decisive and implement my own circumstances. I did not. I take the court serious, and I will stay away from the station and anything.
There was a warming center exactly across the street from there at the library.
At the library?
Correct.
I haven't heard of that place.
You haven't heard of the library?
No, I know the library, madam, but across the street from the library, I had not heard.
It's a warming center as well.
Is it called?
It's literally across the street from the CATA. It's 1 block up.
So that's Jim Ho's. Jim Ho's doesn't allow me to go there because I don't have a mental circumstance. And they were.
I don't know what that means. I don't know what a mental circumstance means.
They tell me because I'm not working with community mental health that I can't go there.
They can't prevent you from going to the library, to the public library, for the use of it as a warming center.
Okay, I did.
Unless you've already been trespassed from there, which I would not have any information regarding that.
I am not trespassed from there. No, ma'am.
You are not allowed to be at the CATA whether it's 75 degrees outside or 7 degrees outside. You have to access another warming center, sir. Do you
Okay.
understand that?
Yes,
You're
ma'am.
not allowed to be at the warming center, whether it's business hours or whether you perceive it to be closed. Do you understand that?
I understand.
Okay, you have to access another facility to get on the bus if you wanted to ride the public transit at this time, or you must access another warming center, because at this time, the allegation is that you have either threatened and or assaulted someone that works there. Do you understand that?
I understand, ma'am.
Do you have any questions about that?
I do not. That's the
Are we
moment.
100% clear about your bond conditions and about where you can and cannot go?
Yes. Your Honor.
We'll give him credit time served for the violation. You need to appear in person for your final pretrial, April 7th at 8 a.m. Do you understand that?
Yes, Your Honor. Yes, yes.
Any additional matters for the record?
Not from the people.
No, Your Honor.
You're all set, sir.
Thank you, ma'am.
Thank you.
Yes, ma'am. Thank you.
State of Michigan versus Rhonda Wade, 25-03773. Appearance, please.
Hannah Buckingham on behalf of the people.
Assistant Public Defender Jessica Straub on behalf of Ms. Wade. I'm not sure if she is here via Zoom, but she intended to join you soon.
Rhonda Wade, did you hear us call your name?
I'm here.
Start your video.
I do not know how to start the video.
Okay, we'll let you work on that. State of Michigan versus Akila Thompson, 25-02756. Appearance, please.
Hannah Buckingham on behalf of the people.
Assistant Public Defender Jessica Straub on behalf of Ms. Nicola Thompson, who's here to my right.
Ms. Thompson is scheduled today for sentencing. I do have a pre-sentence report. It was prepared on February 25th. Counsel, did you get a copy?
Did, Your Honor.
Yes, Your Honor.
We need to make corrections, updates, or deletions.
Not from the people.
Not from defense.
Your Honor, I do have a victim that would like to participate in sentencing. Would Your Honor be willing to let me go grab her?
Absolutely. I thought you were getting your victim.
I am.
Oh. Is there a reason why she's sitting?
Oh, sorry, Your Honor. I
Okay,
wasn't
you
sure
want
if
to
wanted
give a
make
statement to the
right
court?
away. Yeah.
You can give your statement at this time. State your name first and last for the court.
Evangeline Anderson,
Okay, can you spell it, please?
EVANGALEAN.
You can make your statement.
Your Honor, I would like to state that this situation has impacted me and my family very significantly. I moved up here to Michigan with my wife, Akira Thompson, and I have no family here and zero outside support other than professionals. This situation has made it impossible for my children to understand that their mother is gone, their other mother. I've had to take care of a newborn baby by myself when I thought I was going to have support. I would like for you, Your Honor, to take this into consideration when you're having Akila do certain classes. I think that she does not understand the impact that she has made on this family. Thank you so much, Your Honor, for letting me speak.
Anything else that you wanted to share? You don't have to, but that's
You don't
all.
have to. If it all is possible, I think counseling, if it ever could be on the table, so that there can be closure for my children's sake.
Counseling for what purpose?
Family counseling, because we are still legally married.
Okay, I have no authority to order family counseling under these circumstances. My recollection even was that there was a request by you to remove the no contact order, to which the defendant thought it was safer for her to keep the no contact order. So it's up to the defendant if the defendant wants to do counseling, or if you all go through a family court issue, regarding custody or anything like that, they may order that. But this court is here solely to deal with a domestic violence situation, and I will not be ordering any family counseling. Okay, thank you. Okay, counsel, you can make allocution.
Thank you, Your Honor. Ms. Thompson would like to apologize to the court for her actions leading up to this encounter. She does take full responsibility for her actions. We have looked thoroughly over the recommendation from the probation office, and to make it clear to the court how serious she is about her accountability, she has taken steps and initiative towards some of these recommendations already, Your Honor, specifically in that third to last paragraph where it is recommended that she engage in training for problem-solving skills, identifying emotions, understanding barriers to change, and conflict resolution. She has completed multiple courses online, Your Honor, through Allison.com. One of those courses is Understanding Emotional Mastery. Another is Anger Management and Conflict Resolution. And lastly, Problem Solving and Critical Thinking Skills. She has done all of this, Your Honor, with the intention of improving herself and taking this matter very seriously and taking full responsibility moving forward. As such, we would ask this court to consider that in its discretionary sentencing. Thank you.
Does your client wish to make a statement today? So the court has reviewed the pre-sentence report, the prior criminal history, which there is no prior criminal history other than this one conviction, and then the statement that was allegedly given to the probation officer in consideration of the pre-sentence report. Also understanding that there has been no objection to sentencing under 769.4A. The statements, ma'am, that you've made that were reflected in the pre-sentence report differ a whole lot from what was alleged to have happened in the affidavit of probable cause. In your statement, it appears that there was a situation where you just lost your control for a split second.
Made a split second very bad decision.
Okay. And that's what caused you to be here. I would say that the information in the affidavit of probable cause and the police report, which is inside of the sentencing file, do show a bit more than a split second decision. It really narrates a situation where you lost it for a little bit longer, but it looks like at the time you were trying to leave or separate at that time anyways. Is that accurate? And I think you shared that even at the time of your pre-sentence interview, that this was a situation where you had been struggling with dealing with your significant other's mental health spirals, and that they were having an impact on you and your own mental health, and that you believe you probably should have vacated quicker. But in this moment, while you were trying to gather your things, the situation got agitated and you lost control. I'm happy to hear that since this time, you have taken it upon yourself to engage in some rehabilitative classes, because I can order you to do a number of things, but if you don't have a desire to change and to take some responsibility for your own actions, you won't make a change. So that's completely and solely up to you. And the fact that you have reported here having already done some of those things shows good faith that you're really trying to make sure that you don't find yourself in this situation. I think it also states that you are or will continue to be seeking some therapy through community mental health. That's something you're already doing. So those were mostly the things that the court was already planning to order you to do anyways. Are you employed?
I'm currently in a employment program, seek gainful employment with Peckham.
Okay, okay, that's what I thought. It said something about that. Okay. So I'm going to order that you continue to do your working with Peckham to hopefully find you some meaningful employment. And then you'll have to provide evidence of that to probation. Do you understand that? In order that you continue your counseling of community mental health. And provide evidence of that. You will be required to complete domestic violence counseling if you've not already done so, and provide evidence of your completion of that as well, okay?
Yes, ma'am.
Okay, the recommendation is for 10 months of probation. Two things. There's no prior criminal history. There's been no violations of bond conditions. This has nothing, I don't believe and hope that this will be a continuing incident. And the other thing, if I give her 10 months, she doesn't even have the option of requesting early discharge. So I'm going to start her, instead of 10 months, I'm going to give her 5 months probation. While on probation, you're not to engage in any assaultive or threatening behavior. Do you understand that? You're not to use, purchase, or possess firearm, ammunition, or weapon of any kind. You're also not to use or possess alcohol, marijuana, or controlled substance. However, I am not ordering substance abuse testing. There's no history of substance abuse or use. It's not even addressed in the report, except for a request to have or do testing, but it wasn't even mentioned in the police report that this was, that alcohol or a substance was somehow related to this incident. So it's not meaningful, and it's just an expense that she likely can't afford. But you're not to be at any bars or nightclubs while you're on probation. Do you understand that?
Yes, ma'am.
Although I am not currently ordering you to test, if while on probation, it becomes an issue, I can order you to start testing. You would have to pay for that, okay?
Yes, ma'am.
Okay. Let's see. I've already ordered you to complete the domestic abuse programming. And to continue working with Peckham. There's a $30 per month oversight fee for each month of probation that you must be responsible for. There's also a $75 excuse me, crime victim rights fee that you would be responsible for, plus a $50 state minimum cost that you're responsible for. Prosecutor cost recovery is $120. I don't see anything for the recovery for the public defender's office, so that will not be assessed. I don't see restitution, so that will not be assessed. So if you do 5 months of probation, it's gonna be $150 for probation fees. I'm waiving discretionary fines and costs. Your total fines and costs will be $395. And the expectation is that you'll be making monthly payments on that, okay?
Yes, ma'am.
Which would be about $79 per month. Make monthly payments on that. Do you have any questions at this time?
No, ma'am.
Gonna have you check in with our probation department. Oh, I'm sorry. I'm also gonna continue the no contact order. No contact order between you and Evangeline Anderson will continue.
Your Honor, would you like the course completion certificate for the file?
Those are our copies?
Yes, Your Honor.
Okay, absolutely. Thank you. I'll attach this. You're gonna check in with probation before you leave. You will be able to report monthly to probation via Zoom, okay?
Yes, ma'am. Is that a requirement to report monthly, or are you just able to?
You are able to. You can let them know if that's not something you want to do, that you would like to report in person. Let them know that. Okay, any additional matters for the record?
No, Your Honor, thank you.
Thank you. You're all set.
Thank you.
On the record in the matter of the state of Michigan versus Dominique Belafont. This is 25-03267.
Hannah Buckingham on behalf of the people.
Morning, Your Honor. Dustin Coons for Dominique Belafont. We are approaching.
This was a final pretrial, correct?
It was, Your Honor.
And I also have a bond violation. Is the witness here?
Your Honor, I did not have the bond violation listed in my system. And I also know that we had told the victim that he didn't.
No,
need to
we did say that. I see my note here.
Because of previous.
So this is gonna continue to trial on the 28th.
That's right. Yeah.
Now we have to address your bond, because the allegation, ma'am, is that you violated your bond conditions. Allegedly, on or about the 2nd of February at about 11:14. The allegations are that you were present at 6500 West Mount Hope Highway, which is the place of work of the alleged victim, and that you were present inside of your vehicle, GMC Yukon Silver in color, recording the alleged victim. That would be a violation of your bond conditions, and you could be facing 93 additional days in jail for that. Do you understand that? How does she want to proceed for that?
Your Honor, we ask that the court enter a not guilty plea.
I'm going to enter a not guilty plea. I am going to order her on GPS tether now, though.
May I assume you like her in the jury box?
That's correct.
Okay. May I step out in the hall, my client, to explain that?
To explain what?
Just the court's order for tether.
Well, I'm gonna, it's pretty clear. You gotta get a tether. You're not to, because you're not to be within 2,000 feet of wherever Alonzo Thomas lives, works, or goes to school. And there's a violation of what could be potentially stalking activity. So I gotta have you sit in the jury box so that you can be transported to Ingham County Jail so that they can put a GPS tether on you. Then you can be released. You understand that? Is that what you wanted to explain?
More or less, Your Honor. Thank you.
No problem. Do you have any questions about that, ma'am? Okay, you can have a seat over there.
Around that way, yeah.
Is David Cheney here? His name is familiar, doesn't sound like someone. Never know. I did send Miss Wade a request to start a video, but then it's not started, so.
I'm here.
David Cheney's not here. I haven't seen it. Okay, bench warrant failure to pay. On the record in the matter of the state of Michigan versus Rhonda Wade in file number 25-03773. Appearance, please.
Anna Buckingham on behalf of the people.
Assistant Public Defender Jessica Straub on behalf of Ms. Wade, who is here via Zoom.
Okay, Ms. Wade has an assault and battery pre-trial today. Was there an offer extended?
Not at this time, Your Honor. We'd request to move to final pretrial.
Pre-trial April 7th at 8 a.m. And jury trial May 12th at 8 a.m. Final pre-trial April 7th, 8 a.m. You must appear in person at the court. Jury trial May 12th, also at 8 a.m. in person at the court. Okay, Ms. Wade?
Yes.
Do you have any questions at this time?
No, ma'am.
Any additional matters for the record?
Not from the people.
No, Your Honor, thank you.
Thank you. You're all set, Ms. Wade.
Thank-
I remain for a GPS tether. Ms. Belafonte.
Okay.
Thank you. However, Mr. Coombs,
I'm sorry, yes, sir.
I think the other option is you could ensure that she goes and gets the GPS tether. Then I don't have to remand her. But she would have to go straight there today to JSG.
Your Honor, I'll do whatever I have to do.
That's what you want. That's what you, okay, you can
Okay,
do that.
Thank you, Your Honor. I appreciate that very much. Yeah,
You can hold off. Since she does have private counsel.
okay.
He can take her to ensure that she gets GPS tether versus her being remanded.
Thank you so much.
Thank you. Is Mark Anderson downstairs?
He's supposed to be on.
Of course.
Let me-
Oh, we're early though. We're early, so
Oh,
we're gonna
I'm
give
about
him
to say,
some, we'll give him some credit.
I used to my number now.
We're already at the 10 o'clock. No one else is here yet. Got it. And then Ross is here.
All right, yes, ma'am.
Sir in the jail, what's your name?
Defendant trial, I didn't think
Jerry,
it would go
Jerry.
For that one.
Thank you.
Jerry.
Other gentleman, what's your,
This
all
is
right,
my-
which, other gentleman, what's your name?
Now asking.
Sir, what's your name?
What is the
Last
first
name is Rob, my first name is Rob, and last name is Cole.
name?
All right, thank you, sir.
Magic like that.
Mark, State of Michigan versus Mark Anderson, 23-01522, 23-02918, 25-01805, and 25-02000. Appearances, please.
Ralph Marchino for the people on all 4 files.
Assistant Public Defender Justice Rob on behalf of Mr. Anderson, who is here remotely.
Okay, Mr. Anderson has all files are assault and battery charges. How, and then I think one is aggravated assault. How are we proceeding?
It is my understanding, Your Honor, that we are pursuing a global resolution along with this county file. I do believe that is through 55th District Court. Anna, is that correct?
Yes, Your Honor. Yes, Jessica.
He has a felony.
He does, Your Honor.
This is not court date on the phone.
My records reflect March 26th, Your Honor, at 9:30.
We will reset this after that.
I'm sorry.
We will reset this after that date.
Okay, thank you.
We can do March 31st at 10:30.
Any additional matters for the record?
Nothing for the people.
We're all set, Mr. Anderson.
All good. Thank you.
State of Michigan versus Suzanne Christensen, 26-00445. Appearance, please.
Ross Marshall, after the people.
Public Defender Justice Rob and Suzanne Christensen, who is approaching.
We have an appearance. When was your appearance title?
My file does not reflect when that would have been drawn.
Here, so we'll need one from your office. Would you receive discovery?
Yes, I have.
This is an assault and battery. Is there an offer at this time?
Not at this time, Your Honor.
Final pre-trial?
Yes, Rob. April 14th at 8 a.m. for the final.
May 12, for the jury trial. Okay, you must appear in person on April 14th, 8 o'clock in the morning for a final pre-trial. And then there's a jury trial scheduled for May 12th at 8 a.m., okay? We'll get you a notice with those dates on it. Do you have any questions at this time? Any additional matters for the record?
Nothing for the people.
No, Your Honor, thank you.
Okay, we'll get you notice. State of Michigan versus James Nash, 26-00242.
Ross Marshall, after the people.
Assistant Public Defender Justice Rob on behalf of James Nash is standing to my right.
Okay, Mr. Nash is here for domestic violence. Is there an offer at this time?
Not at this time, Your Honor.
How do you want to proceed?
Proceed to final pre-trial.
Final pre-trial, April 14th at 8 a.m. And then jury trial, May 12th at 8 a.m. You must appear in person for both those dates, okay? Do you have any questions for the court today? Is that enough? We'll get you a notice to appear. Any additional matters for the record?
Nothing for the people.
Nothing for the Thank you.
State of Michigan versus Devon Verser McKinley, 24-03208. Appearance, please.
Ross Marshall, here for the people.
Morning, Your Honor. Joseph Yang on behalf of Devon versus McKinley, who is present in Sumo.
Okay, Mr. Verser McKinley has an aggravated assault and battery. Are we continuing to final pretrial, or has this been resolved?
I will be continuing the final pre-trial, Your Honor.
That's correct, Your Honor.
April 14th at 8 a.m. That works for you, Mr. Yang.
Your Honor, I'm unavailable that day, was the 21st.
You can do the 21st at 8 a.m. in person at the court.
Thank you, Your Honor.
No problem. Jury trial, May 26th. Does that work for you, counsel?
That works for me, Your Honor.
May 26th, 8 o'clock in the morning, in person at the court. Do you have any questions at this time? Any additional matters for the record?
Nothing for the people.
Nothing from the defense, Your Honor. Thank you.
Thank you. You're all set. State of Michigan versus Robin Cole, 25-0255. Did they put Cole on? Or she's right on.
Ross Marchino. People.
Hey, please, court, Dan Doyle, here on behalf of Mr. Cole. Mr. Cole is in jail.
No, Mr. Cole.
Yes, sir.
Okay, thank you. How are we proceeding? This is a breaking and entering illegal entry.
Your Honor, the people will be requesting that it be set for trial, pre-trial, and jury trial date.
Yes, Your Honor, thank you.
April 14th at 8 a.m. Final pre-trial.
My apologies. I didn't know how that happened.
And May 26th at 8 a.m. for jury trial.
April 14th, 8 a.m. in person at the court for a final pre-trial and then jury trial, May 26th. Also in person at the court. Do you have any questions for the court today, Mr. Cole?
No, ma'am. They didn't work the.
Okay. Any additional matters for the record?
Nothing for people.
No, Your Honor, thank you.
Thank you, Mr. Cole. You're all set.
Thank you. God bless.
Thank you. State of Michigan versus Jerry Gary, 26-007278.
Yes, ma'am. Ross Marchino for the people.
Assistant Public Defender Justice Job on behalf of Mr. Jerry Gary, who is here to be a polygraph.
This is a retail fraud second degree pre-trial. How are we proceeding?
Your Honor, it's my understanding that we do seem to have a plea agreement regarding the charges. However, it sounds as though Mr. Gary is disputing the restitution request.
Counsel.
That is correct, Your Honor. Mr. Gary attests to the fact that he was encountered by police after leaving the mire, and that they did recover the meat at that time.
They recovered the meat?
They did.
What do you think they were supposed to do with it after it was recovered? Put it back on the shelf and sell it?
I have to try, Your Honor, but.
It was a good faith effort.
We have a restitution request from Maya requesting $174.44.
Well, was it steaks?
It was, Your Honor.
Got it.
Couple of roasts.
Okay, he wants to plead guilty
That's
to the original charge. Is that correct?
I believe we're reducing it to third degree.
Okay. You want to plead guilty to the amended charge of retail fraud in the third degree?
Yes, Your Honor.
All right, raise your right hand. You solemnly swear or affirm the testimony you're going to give us the truth and the whole truth under penalty of perjury.
Yes, ma'am.
Okay, you can put your hand down. Mr. Gary, you understand that you could take this matter to trial. That is your right. And at the time of trial, you can require the prosecution prove each element of the charges being brought against you beyond a reasonable doubt.
Yes, Your Honor.
You understand? Okay. You have the right to remain silent at any trial and not have silence be used against you, or you can waive silence and testify at your trial if you like. You have the right to see, hear, or question any witness called to testify against you, the right to subpoena witnesses that will testify on your behalf, and the right to present evidence that you believe show a defense to the charges being brought against you. You understand those rights?
Yes, ma'am.
And are you willing to give up all of these rights today?
Yes, ma'am.
Is there anyone threatening you to get you to plead guilty?
No, ma'am.
Have you been coerced to enter a guilty plea? I didn't hear a response. Have you been coerced to enter a guilty plea, sir?
No, ma'am.
Are you currently on probation or on parole?
No, ma'am.
You understand, by entering a guilty plea, it can result in a conviction that you may need to report to a current or future employer.
Yes, ma'am.
It also can have impact on where you can travel or get immigration status.
Yes.
Okay. And as to the amended charge of retail fraud in the third degree, are you looking to plead guilty because you believe you are guilty?
Yes.
Okay, as to retail fraud third degree, how do you plead?
Guilty.
Actual basis, please.
Mr. Gary, were you on or about September 25th of 2025 located at 6200 South Pennsylvania Avenue in Lansing, Michigan?
Yes.
And is that place Meyer?
Yes, it's Margaret.
And is that located within the county of Ingham in the state of Michigan?
Yes.
And while the store was open to the public, did you indeed steal some of its property from the store?
Yes, I did. I stole some ribeye steaks.
Okay, and was the value of those steaks around $174?
Yes.
Do you think that would satisfy the factual basis?
He works outside.
The court is also satisfied with the factual basis. I find your plea to be freely, voluntarily, and intelligently made. He's in custody for what now?
For a felony.
And it's going to be in custody for how long for the felony?
Well, he actually would like to petition the court at his upcoming arraignment to be released on PR2 treatment.
Upcoming arraignment on the felony?
Yeah, I think he's being arraigned in 30th.
He requested someone motion for him to be arraigned in 30th?
I do believe so. I think they moved the file from 54B.
It's bind over,
I do believe so, yes.
but you don't get an arraignment unless there was a motion filed
There was a motion filed by Jonathan Foreman, Your Honor.
for an arraignment in circuit court.
Yes.
Okay. So
He has another felony.
He
has it's a warrant status.
he doesn't file a warrant status here.
The only warrant I have is in Jackson. And I can get that taken care of because I try to prevent all this, but they put me into treatment the 30th of January with an active warrant. So that's why I'm back. I was only out 6 days. Then they rearrested me, going back to St. Harbor because I had an active warrant out of East Lansing and Judge Lisa Babcock's courtroom. And they didn't believe me. I don't know if that's gonna help me or.
I'm assuming that's the case that was bound over, but you have another case here.
I have another case here?
That's what I'm waiting for them to bring me the file.
I believe I forwarded it to you.
Christian. Give me his criminal history too. I just need a view hole punch for that because they missed it.
Oh,
They just stuck it in here. This is the matter of the state of Michigan versus Jerry Gary 26-00579. I just need the public defender's appearance. He's not been arraigned on this. Appearance for the record.
Assistant Public Defender Jessica Straub on behalf of Mr. Jerry Gary for purposes of arraignment today, Your Honor.
Okay, Mr. Gary, I have here a felony complaint. The allegations are that on or about a time frame of October 15th, 2025 through December 1st, 2025, that you did allegedly at the area of 350 Frandor Ave, Lansing, Michigan, commit the acts in count 1 of retail fraud on or about October 15th. Retail fraud at that address on or about, and that's first degree, that is October 19th at 350 Frandor Ave, on or about November 16th at 350 Frandor Ave, a retail fraud first degree, and or about December 1st, 2025 at 350 Frandor Ave, another retail fraud first degree. All counts 1 through 4 allege that you did, while Ulta was open to the public, steal property of that store that was offered for sale at a price of $1,000 or more, contrary to Michigan Compiled Law 750.356C. Therefore, this violation of MCL 750.3561 D1 constitutes retail fraud in the first degree, which is a felony. Each count is 5 years or punishable maximum penalty 5 years in prison and or $10,000 in fines, or 3 times the value or difference in the price of the property stolen, obtained, attempted to be obtained, whichever is greater. To impose a fine of 3 times the value, the defendant must either admit the amount or it must be determined by a trier of fact. Do you understand the charges in counts 1 through 4 and the maximum penalty for each count?
Yeah.
There's also a notice of intent to seek enhanced sentence as fourth habitual offender notice under MCL 769.12. That says, take notice that the defendant was previously convicted of the following felony offenses or attempting to commit the following felony offenses, that on or about April 30th, 2025, he was convicted of the felony offense of felony controlled substance possession of cocaine, heroin, or other narcotic in violation of Michigan Compiled Law 333.740328.5 in the 30th Circuit Court for Ingham County, State of Michigan, and that on or about September 25th, 2023, He was convicted of the offense of felony controlled substance, possession of cocaine, heroin, or other narcotic in violation of MCL 333.7403-285 in the 30th Circuit Court for Ingham County, State of Michigan, and that on or about April 13th, 2022. He was convicted of the offense of felony controlled substance possession, cocaine, heroin, or other narcotic under MCL 333.7403-285 in the 30th Circuit Court, Ingham County, and therefore the defendant is subject to enhanced penalties under MCL 769.12. That's the penalty of life, and if the primary offense has a penalty of 5 years or more, which your counts 1 through 5 all have a maximum penalty of 5 years or more. Do you understand the charges read in the maximum penalty and the enhanced sentence subject under the fourth habitual offended notice? Do you understand that, sir?
Yes,
You have the right to counsel. Ms. Straub is representing you today so that I could arraign you on this file. You have the right to have an attorney represent you at all of your court appearances. And if questioned by law enforcement, if you can't afford to hire an attorney, you can make a request to have the public defender's office represent you. I am going to note that you are making such requests as you are represented by them on your other files. You have the right to remain silent. Anything you say and anything you put in writing can be used against you. You have the right to plead guilty, plead not guilty, or stand mute. If you stand mute, the matter will continue to jury trial. You are being charged with felonies. You have the right to preliminary examination within 21 days of today's date, because today was the date that you were arraigned. At the time of the preliminary examination, you have the right to have the prosecutor establish that they have sufficient probable cause that a felony was committed, and then probable cause sufficient to charge you as the person who committed the felonies. I'm gonna get you probable cause date and a preliminary examination date. Thank you. You're currently scheduled for probable cause conference before me, Judge Kristen Simmons. Is gonna be on March 12th at 2:45 p.m. You have a preliminary examination before me, March 20th at 9 o'clock in the morning. You must appear in person for your preliminary examination. Again, if this matter proceeds, if this proceeds beyond a preliminary examination, you have the right to jury trial. You have the right to the presumption of innocence. You're innocent until proven guilty. And then you have the right to maintain that at your trial. You have the right to maintain silence at trial and not have it used against you. The right to subpoena witnesses to testify on your behalf. The right to cross-examine or question any witness called to testify against you. I was gonna say, can we? I'm gonna do that. Counsel, you can address bond.
Yes, Your Honor. Relative to the two factors, the first of which being a flight risk, Mr. Gary is currently in custody, so he is not likely to be a flight risk. Relative to the second factor of being a danger to himself or to others, it does appear that he had some interaction with the criminal justice system in his history, but it does appear to be largely unassaultive, Your Honor. And today's allegations pending against him are also not assaultive. As such, we would ask this court to impose a reasonable bond for him today, but in light of him being in custody, if that could not be a PR bond, unless it is released into treatment.
Okay, you said he had some criminal history.
Your Honor.
Do you have a copy of his criminal history?
I do not. All I have is the case list in our case management system.
See how thick this file is?
I do, Your Honor.
This is his criminal history. It spans about 20 pages long. And there are dozens of assaultive actions on his criminal history, amongst others. But what I have here is a situation where he obviously has a matter pending before the circuit court. What was the date of incident on that matter? Or I should say, when was he arraigned on that matter?
It looks like February 2nd, Your Honor.
Okay, it was arraigned on that matter February 2nd, and then it was. The warrant wasn't even requested until February 6th. I don't know how. It was arraigned. What's that, this one maybe? That might, no, this one's the found over. February 6th. It's when the warrant was requested. Nonetheless, what I have here is it looks like a period of time that spanned from October to December, where on separate dates, over $1,000 worth of merchandise was allegedly taken. This is right after he's pled guilty to a retail fraud third, was pled down to retail fraud third, where he allegedly went into well, not allegedly because he pled guilty. He went into the mire and took 8 steaks. Do I think he was going to eat all 8 of those steaks? I do not. And then I'm assuming that the case that's bound over is also a retail fraud. Well, I don't have to assume, I have it here. Was also retail fraud in the first degree, correct? No, look, there was a controlled substance and retail fraud second degree that was found over, and assault and battery. So he's got pending drug theft and assaultive crimes pending. I know there was a statement made that he was going to petition the court for a release. I don't think he needs to be released. I think he's a threat to the public safety in all areas, obviously in a assaultive nature. He's continuously stealing, probably for the purposes of the other pending charge, which is drug use. And he has, based on his criminal history, dealt with drug use issues for a while. That's why he's got this as an enhanced fourth habitual offender. All of those convictions were felony controlled substance convictions. So no, I don't believe that he's not a threat. I think he is a threat to both himself and to the public safety. So bond will be set appropriately in the amount of 5,000, 10% on this. If bond is posted, he will wear GPS tether. He will participate in weekly urinalysis testing 1 time per week. He's not to use any drugs or alcohol without a prescription. He's not to possess a firearm or any other dangerous weapon. He's not to travel outside the state without prior approval of the court. He must report to pretrial services within 48 hours of his release from custody. Can you confirm your address, please? Confirm your address, Mr. Gary.
5303 South Cedar Street. I mean, I was staying at Safe Harbor, but they entered a warrant out for my arrest when I got released to treatment. You know, so.
Okay.
All these under review, and I was being released.
Okay, sounds,
To Judge Kennedy.
okay, sounds good. So he must have had another matter where he was under sentence by Judge Buchanan. That was not any of the three that I just mentioned. Okay, sounds good. Okay, so we'll see you for your probable cause conference on March 12th. At 2:45. Well, you'll actually see Judge Buchanan on that date for the probable cause conference. You'll see me for your exam. Any additional matters for today's record?
No, could you repeat the file number?
The what?
The file number.
This is 26-00579.
Thank you.
For the record, the court has entered a not guilty plea on your behalf on that file. And then we will refer him to sentencing on the 26-00278.
April 28th at 9 a.m.
April 28th at 9 a.m. for sentencing on that. Any additional matters for today's record? Thank you, you're all set.
It's all right if I talk to Ms. Jessica in the breakout room?
She can absolutely log in and speak to you in a breakout room, and then once you're done with that, you're free to go, okay?
Yeah.
Okay, the jury should be here, correct?
Police.
Oh, Miss Travis. There it goes. Let me see if it's allowed.
Good, it's already. Second, so I go down and check on the jury. I'll check the quiet. So.
They are here.
No, I don't know. I'm gonna go down there and double check and see.
How do you have your radio?
Yes.
Okay.
Your Honor, I have the plea agreement sheet for Jerry Gary.
Thank you. That Jerry Gary fire also needs a referral for probation.
I'm doing it now.
I'm just telling him so he doesn't take it out of here.
Do it again.
Oh, yeah. I'm not done. Copy that. And then, oh, yeah,
Can I get a copy of that?
yeah, you gotta say copy. You know, everybody hears the radio. No.
Oh, no.
It goes to everybody. Everybody, all the people with the radio can hear this.
Thank you.
The jury here? Oh, okay. Okay, back on the record in the matter of the state of Michigan versus Garrett McCullough, 26-00025. Can I have your appearances again, please?
Ross Marchvina, now here for the people.
Jerry Faber on behalf of Mr. McCullough, who is present. Great.
Okay, the jury is here, and Mr. Wormsley has gone to retrieve them. I did have procedural and instruction before trial sent for your review. Do we need to make any additions at this time or changes?
I don't believe so.
I don't believe so either. I had a discussion with the prosecutor. I have no objection to the proposed exhibits from the people, so I have no objection to those being marketed, stipulated.
You can get the mark if you have it.
And I likewise have no objection to the defense has one proposed exhibit.
You can both get your exhibits marked now if you'd like. You can have a seat, sir.
Thank you, Madam Chair.
Oh. Oh. Okay. Again, if everyone can turn their attention here to I have some instructions. Okay, ladies and gentlemen, I am Judge Kristen D. Simmons, and it's my privilege and pleasure to welcome you and then introduce my staff. Welcome to the 54A District Court. I know that jury duty may be a new experience for some of you. Jury duty is one of the most serious duties that members of a free society are asked to perform. Our system of self-government could not exist without it. The jury is an important part of this court. The right to a jury trial is an ancient tradition and part of our heritage. The law says that both a person who is accused of a crime and the prosecution have a right to a trial, not by one person, but by a jury of 6 impartial persons. Jurors must be as free as humanly possible from bias, prejudice, or sympathy for either side. Each side in a trial is entitled to jurors who keep open minds until the time comes to decide the case. A jury trial begins with jury selection. The purpose of this process is to obtain information about you that will help us choose a fair and impartial jury to hear this case. During jury selection, the lawyers and I will ask you questions. This is called voir dire. The questions are not meant to find out if you know, the questions are meant to find out if you know anything about the case. Also, we need to find out if you have any opinions or personal experiences that might influence you for or against the prosecution, the defendant, or any witnesses. One or more of these things could cause you to be excused in this particular case, even though you may be otherwise qualified to serve as a juror. The questions may probe deeply into your attitudes, beliefs, and experiences. They are not meant to be an unreasonable prying into your private life. The law requires that we get this information so that an impartial jury can be chosen. If you do not hear or understand a question, you should say so. If you do understand it, you should please answer it truthfully and completely. Please do not hesitate to speak freely about anything you believe we should know. During jury selection, you may be excused from serving on the jury in one of 2 ways. First, I may excuse you for cause. That is, I may decide that there is a valid reason why you cannot or should not serve in this case. Or a lawyer from one side or the other may excuse you without giving any reason for doing so. This is called a preemptory challenge. The law gives each side the right to excuse a certain number of jurors in this way. If you are excused, you should not feel bad or take it personally. As I explained before, there simply may be something that causes you to be excused from this particular case. I will now ask each of you to stand and swear to answer truthfully, fully, and honestly all the questions that you will be asked about your qualifications to serve as a juror in this case. If you have religious beliefs against taking an oath, you may instead affirm that you will answer all the questions truthfully, fully, and honestly. If all the potential jurors could stand, please, and raise your right hand. Do you solemnly swear or affirm that you will truthfully and completely answer all questions about your qualifications to serve as jurors in this case? If you do so, you signify by saying I do. I do. You can be seated. Okay, I'll now introduce my court staff. I first have Addie Nash. That's my court recorder and judicial assistant. Over to my left is Mr. David Warnsley. He's the court officer and the gentleman that escorted you upstairs. This is a criminal case involving the charges of domestic violence, and we will explain that more fully later. I didn't change that. This charge has been made against the defendant. It's actually Garrett McCullough. The defendant's attorney is Mr. Gerard Faber. Mr. Faber, please list any witnesses you anticipate calling in this case for the trial.
Garrett McCullough, Officer Tyler Stover.
Thank you. The assistant prosecuting attorney is Ross Marchmina. Can you pronounce that for me?
Marchmina.
Marchmina. Okay. Mr. Ross Marchmina, please list any witnesses you anticipate calling in this trial.
Hello, everyone. We plan to call most likely 2 witnesses, Nicole Polka and Alexander McLean. Thank you.
Does anyone in the jury box or anyone waiting to be chosen to go to the jury box know or recognize any of the lawyers that just introduced themselves? If you do, just raise your hand. Okay. Anyone recognize the names of those witnesses? Very good. This trial should last one day, but there's the potential it could go over into tomorrow, just the way, I don't know how long the witnesses will take. If you believe the length of trial will be a true hardship, please raise your right hand. Some of you may have health problems that would prevent you from serving on a jury. For example, does anyone have a medical problem that makes you unable to sit for 2 or 3 hours at a time? Or does anyone have a sight or hearing problem? So taking the first question, anybody unable to sit for longer than an hour at a time? You have an issue, sir?
Yes, I do.
Okay, a medical issue, so you can't sit for longer than an hour? I'm sorry, I couldn't hear you?
I got this here, most later, and my neck, my back is pain.
Okay.
My back
I noticed when you walked up that you appeared to be in some pain. Okay,
And I'm currently in physical therapy.
okay, sounds good. I'm going to excuse you, okay? Thank you for your service. Feel free to go. And Rachel Faher will replace that seat. Thank you, sir. Juror number 3. Okay, next. Can everyone hear me? If you can hear me, raise your hand. Everyone can hear me. Very good. This is a smaller courtroom, but everyone can see us up here, correct? Okay, very good. Again, this is a criminal case. The paper used to charge the defendant with a crime is called a complaint. The complaint in this case charges the defendant, Garrett McCullough, and reads as follows: that on or about January 4th, 2026, at 1014 RG Curtis Ave, which is in Lansing, Michigan, as the defendant did allegedly commit the acting count 1 of domestic violence, and that he did allegedly make an assault or assault and battery upon a Nicole Ashley Polka, an individual with whom the defendant had a child in common and or a resident or former resident of his or her household and or his or her spouse or former spouse, contrary to NCL 750.812. The defendant has pled not guilty to the charge. You should clearly understand that the complaint I have just read is not evidence. A complaint is read in every criminal trial so that the defendant and the jury can hear the charges. You must not think that it is evidence that he is guilty or evidence of his guilt just because he has been charged. A person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements. The prosecution must prove each element of a crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecution has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of this case. I will now let the attorneys do their voir dire.
Okay, thank you everyone for bearing through that first set of instructions. My name is Ross. I have Mr. Hanson at the table with me. He's helping me out today. Juror one, I apologize. I did not catch your name. Joey. Okay. Now, after that, from now on, you don't have names anymore. You all have numbers. Okay. Like the judge said, the purpose of this process is so we can get to know you guys a little bit and get a sense of who's a good fit for this particular jury, right? If nobody's a good fit for any jury, try to get a sense of biases, stuff like that we might have. Does that make sense to everyone? Seeing now, do you have any questions about that, about what's going on right now? And if you're, watching right now, so you're all paying attention because you might be up in here soon getting the same questions. Now getting into it, we'll just hop right into it. This case is about domestic violence. Start here at juror 7. Do you have any experience with domestic violence? Could you? I hate crying, and one thing I like to just say in advance is I during jury selection I draw traumatic things out of people, and it always circles back to, well, how will that affect your future? So I don't want you to think that I'm like some kind of monster who only sees how it affects today. It's just that's how it needs to circle. So I am gonna have to put you on the spot. Could you please tell me about that experience? So
Can you
something
speak up
that-
a little bit, please?
Sorry, I was an EMT, and I responded to a couple of different domestic violence calls.
I see now you're a graduate student. What kind of coursework are you doing?
I'm a physiology graduate student and also obtaining a medical degree.
Now circling back to domestic violence experience through being an EMT, so would you respond to injuries following domestic assaults?
Yes.
But do you personally know anyone who's been involved in abusive relationships?
I have friends who I have suspected of an abusive relationship.
What has caused you to suspect that?
Ways in which they respond to questions and withdrawing from relationships in particular patterns.
So when you say withdrawing, does it seem as though the intimate partner is isolating them? Is that kind of what you're saying? And getting back to EMT, what kind of injuries would you see when you respond to these calls?
Predominantly what we call trauma injuries. So usually bruising, occasionally a broken bone, something due to a physical trauma.
And kind of tie it back in, how does that affect you as potentially being a juror on the case alleging domestic violence?
I would like to say that I can be impartial. I would usually say that I some injuries from them, but
Now, when you say you have strong feelings, I think everybody in this room is going to agree that domestic violence is horrible. And of course, the issue here is whether this defendant is guilty. So you think you're able to recognize? I guess my question is, will these strong feelings cause you to sort of assume, well, he must be guilty? Or you think you're able to recognize it's possible he's not guilty, even though it would be bad?
Innocence, until provided evidence.
So before it can be horrible, right, we have to prove that it happened. And then okay. Now going on to juror number 6. Do you have any experience with domestic violence? Your parents were abusive to each other. And how long was that going on? Okay. Were they married? It seemed confusing to you that they stayed married, even though clearly it was toxic. Looking back on it, do you have any insight into why they stayed together? Convenience. When you say they were abusive towards each other, was there one person who was, I guess, more in control than the other? Your mom was more in control of the abuse. And how does that affect you being a juror in a case of alleged domestic violence? Did you say, I'm sorry, I will need you to speak up.
I wouldn't find someone that can evidence.
Oh, I'm sorry, continue.
Because the fact, I witnessed that.
Would your experience like make it hard for you to sit on a jury in a case like this? No. Now, why do you say that your mom was the one who was the main person in control of that relationship?
She was technically an alcoholic, but she drank a lot, so she supports my dad. And he would
And you say he would fight back, so she would kind of instigate and he would fight back. Now, juror number 5, do you have any experience with domestic violence?
Yes,
Could you please tell me about that?
I believe growing up, I was a victim of violence as well as my siblings,
And who was the perpetrator of this violence?
step parents.
Step parents, so you had multiple step parents who were doing this?
Yes,
Okay. And how about intimate partner violence? Do you have any experience with that?
no,
Do you think that hearing about intimate partner violence would sort of, I guess, trigger your experience with what it seems to be you're describing child abuse? Is that,
yes,
does it seem kind of intertwined to you?
probably.
Does that leave you feeling more inclined to believe someone who says that they were, I guess, abused, or?
Probably.
But are you able to still, do your best to put that aside and recognize that that is presumed innocent?
Yes,
I'm moving on to juror 7, 6, 5, 4. Juror number 4. What about you? Do you have experience with domestic violence?
Don't think so. I'm trying to think through everything. I don't think so.
So no one you can think of that you know was involved in some sort of abusive relationship? You don't have to.
Friend, but not since they were a child.
Okay.
They're like 60 now.
Okay.
So they fought a different world.
Different world. Different how?
Different. His father was I think he was a World War II vet and very, very stern.
Okay. Understood. Now, juror number 3, do you have any experience with domestic violence?
Yes, both of my parents. My dad was the abuser towards stepmom, and my mom experienced it with partners after that.
So your mom was the victim of domestic violence from people not your father.
Not that I know of. I was
Okay.
too young to know
So to your knowledge, your mom was abused by intimate partners who were not your father, and your father abused your stepmother.
Mhm.
And the intimate partners who abused your mother, were they also men?
She said yes.
Yes.
Oh, sorry. We do like having
Sorry.
yeses or nos because it's tricky to type versus uh-huh.
Yeah.
So. And let's talk about your dad and your stepmother. Is that something that you saw firsthand?
Not the beatings themselves, but the after effects.
And how long was this going on? You were seeing the after effects.
They were together for like about 10 years, so on up probably from like when I was 5 to about 15.
And was it a regular, or not necessarily regular, was it something that would happen pretty much throughout those 10 years?
Yes.
Is it confusing to you that she stayed with him even though he was doing this?
At the time, but not anymore.
Why is it not confusing now?
Just as you get older, you learn people and people make their own choices and it's just not for me to understand.
It's sort of, I guess what I'm hearing is you sort of recognize that you're not really able to understand what she went through. Is that kind of what you're saying?
Victim mentality is complex and it's hard to leave until you are done.
The victim mentality is complex and it's hard to use. That knowledge that you have as a result of education, as a result of work. I think, yes, you're a social worker. That's what something you learned in your line of work.
Yes.
That's your number 2. Do you have any experience with domestic violence?
Yeah.
Can you tell me about that?
My older sister and just about every boyfriend she's ever had.
It's sort of that cycle.
Yeah. She just knew how to pick them, and they were all alcohol infused. It wasn't always him that started it. It wasn't always her that started it, but somebody started it. Usually was a physical altercation.
Say physical altercation, was it him abusing her? Was it more mutual?
It was both. It just depended on the day.
Okay. And this was a regular occurrence with your boyfriends. And I guess how has that affected your views on it all?
I basically block what she did and who she dates out.
Okay. You just kind of can't deal with it anymore.
I haven't talked to my sister the better part of a decade. So.
Okay. Thank you for sharing that. Now, juror number 1. Do you have any experience with domestic violence?
Not personal experience. No.
Not personal experience. What about secondhand experience?
There's been a lot of situations that I've been aware of, but they've always been at a distance. Never anyone that I've been very close with or that I've been really involved with.
Okay, so nothing that you've been really close up to.
Right.
Okay. I do have to ask, is he your classroom assistant? What age?
Preschool, 3 and 4-year-old.
Sounds like just pure chaos. Okay. Do you enjoy the chaos, or is it just like you go to work and you just can't do this with your life?
Most days I do enjoy the chaos.
Okay.
There's definitely those days.
Like, do you have days where you're like, I can't believe this is my life?
Yeah.
Okay. All right. Now, start with juror 6 this time. Let's do this way. Show of hands, who here has ever been married? You agree? Have any of you ever experienced a divorce? Okay, you experienced a divorce when? How long ago was that?
12 or 13 years ago.
And was it contentious? Was it amicable?
It was amicable.
Okay. Does anybody know anyone who's been through a contentious divorce? Show of hands. Okay, we'll start here with juror number 7, 6, 5, 4. Yes, know your number.
Memories are very old because I was a child, but I'm fairly certain my parents didn't exactly divorce me. Me and my brother ended up with mom. Had like weekend visitation throughout the years, but don't think it was quick.
And did it seem to you that, how old were you when this was happening?
I was 7.
Okay, so you probably weren't too cognizant of it. Now, juror 3, who have you encountered that had a contentious voice?
My parents did. But throughout growing up, they were always arguing and we didn't get along as my siblings and I grew up.
And how old were you when they got divorced?
It was about like 7 or 8.
Okay, so saying probably what you talked about. what's going on. Now, juror 6, it's the risk of being a little heteronormative when a man and a woman are having a divorce. Do you have any thoughts on whether the system kind of tends to favor one or the other? No. Juror number 5, what about you? Juror 4?
Sorry, the anxiety was.
No, that's fine. You can be anxious. That's allowed.
Good, because I am. I only really have the one experience.
Okay.
But
You don't
it
have
seems
opinions on.
maybe slightly more towards the mother, but it really depends.
What makes you say that it might be tilted towards the
Just from
wife or mother?
various like cases I've heard, I can't think
Okay.
of a specific one, but in general, when people talk, it seems like not like mother always gets the children, but it seems to slightly
Slight tilt in that.
a slight tilt. Yeah,
Okay.
not a full on.
Is this just sort of based on things you've heard?
Things I've heard mostly. Yeah.
Is it something that like you believe, or is it just something that like I've kind of heard?
More I've kind of heard that.
So if someone were to come up to you and say, wow, my ex-wife robbed me blind in the divorce, would you think, well, that kind of trap, that sounds right? Or would you think, he might be judging?
I'd say probably a little bit of both.
A little bit of both.
But more towards the, well, why? Why did she get everything?
You wouldn't just assume.
I wouldn't assume that it's
she's
just
being
big bias,
Okay.
like court bias.
Okay.
Like, what did you do to deserve that?
Okay, you would want more info.
Yeah, I'd want more info.
She stole all his money. Okay.
Yeah.
Now, juror number 3, do you have any thoughts on whether the system favors husband or wife?
I think when I got divorced, it used to favor the mom, but from what I've heard from friends that have gotten divorced more recently, it's more like down the middle where it can go either way.
Okay. Understood. Juror 2, what are you? Don't have an opinion on it. Juror 1, how about you?
I don't have an opinion either way.
Now, let's start with juror 5 this time. Do you know anyone who has ever filed a false police report? Just total fabrication made up. Juror 4, do you know anyone who has ever completely fabricated a police report? Juror 3, do you know of anyone who has done that? Juror 2, what about you? Juror 1? Juror 7, do you know anyone who has? Okay. Juror 6. I'm starting at juror number, I just started with you, right? Starting with juror 4. Do you think when two people are telling different versions of the same thing, do you think that you're able to get a sense of who's telling the truth?
I think so.
Okay. What do you look for?
Body language and attitude, I think. Like sometimes you can kind of tell when things are maybe a little more exaggerated. sometimes not true.
How about you?
There's, I think there's some truth in both stories. Maybe where the overlap lies, how their body language is, if they're making eye contact.
Do you think that you're able to assess who's telling the truth and might be lying?
To a certain degree.
Okay. What might you need to be able to say this person's telling the truth, this person's lying? If that's even possible.
More than one side of the story or more than one version, because there's always going to be, to get at least more than one side of the story, kind of put those together and see if there is any overlap or any similarities and there.
Okay. So if it's just one person's word against someone else's word, it's going to be difficult for you to determine.
Not difficult, but like if you're just talking to one person, you would just need more than just the one person.
You
So
want to
if
have
you had-
multiple perspectives.
Yeah, like at least the two people.
Okay, that makes sense.
Yeah.
Juror number 2, you think that you are able to sort of sort out if one person's telling the truth, one person's lying?
To a certain degree.
What do you kind of look for?
How well I know a person. How in character their story is.
What about with strangers?
I just approach a stranger cautiously and telling me what could be a big fish story or honest truth.
Juror 1, how about you?
With strangers. Sometimes I can tell. My body language and how to do the tone. Comparing two different sides of the story.
Juror number 7, what about you?
Similar to other jurors, I don't expect that both sides have some truth, sides some non-truth. Just good feature and try to look for overlap and look at body language and consistency.
Juror 6.
Read their body language.
Juror 5.
Pretty gullible, so I honestly don't know how well I would sort things out like that. I would obviously be looking to see where things overlapped and what made sense. But
Now, when you say you're pretty gullible, what do you mean by that?
my brother used to come up with all kinds of stories when we were younger, and I would believe him.
Okay.
Even simple things like Dad's here, to pick us up. And we run around the house trying to get all of our bags and stuff, and he wasn't there yet. Just simple things, small things, but then other bigger things, he would just make stuff up, and I would believe him every time.
So if you have multiple versions of something that happened, do you think that it'd be hard for you to sort out whether or not one person is being more truthful?
Possibly. Like I said, I would be listening for overlap, trying to see body language, if, somebody seems to be more open or more closed off. But I don't know if I would be the best judge of truth from strangers, since I'm not very good with my own family.
Well, thank you for being so honest about that. I think that's all the questions I have.
Thank you. Morning, everybody. My name is Jerry Faber. It's my client Garrett McCullough. Raise your hand if you believe that you are an emotional decision maker or a logical reason decision maker. So for instance, buying a car, everybody's experienced buying a car before, I imagine. Some people want the car and driver report and the mileage and the statistics and crash rating. That would be like a logical decision maker. You've got other people that say, hey, our neighbor just got this, the exact red convertible that I want. I want that car in my driveway. And I'm going to get that car, regardless of all of the logical, reasoned, analytical approach. So raise your hand if you think that you're more on the emotional based decision making scale. So am I to assume that if everybody's going to raise their hand on the logical reason, or does it matter what you're deciding? Number 5.
I feel like I'm more logical.
Okay. Medical student, more logical?
Yeah.
Okay. Sir, number 4?
A little bit of both. It depends on the situation. Like with a car, I'd probably go for, this is the one I want, but let's see if it's a good car.
Okay. All right. Juror number 1, you heard the judge's instruction about presumption of innocence. Okay. So if the judge said, let's say that this is the jury, and the judge said, ladies and gentlemen of the jury, what is your verdict? As you sit here right now, what is your verdict as to my client, Mr. McCullough?
We haven't heard any information or any evidence. I would have to say innocent because we don't have information.
Okay, that's exactly right. Does everybody agree with that? All right, because when we're all, and I think the prosecutor would agree with me, we're trying to get a fair and impartial jury. That does not mean that your starting point is neutral. Does everybody understand that? Presumption means at the start, pre-trial. As we sit here, my client is not guilty. He is innocent of these charges until and unless the prosecutor lifts that presumption of innocence and proves every element of the offense beyond a reasonable doubt. Does everybody agree to go into this trial? It's not going to be a long trial. Going into this trial with that presumption, that's starting point. Okay, anybody not? Raise your hand if you don't think you can do that. All right. Juror number 3. What's the burden of proof that the prosecutor has in the trial today?
They have to prove that the defendant actually did the crimes that they're being accused of.
To what standard? To what degree? To what level of certainty? What's the burden of proof?
100%.
It's actually not 100%. So it's beyond a reasonable doubt, right? Why is it not 100%? Like if I were to ask you,
I guess they weren't there.
right? So if I were to ask you, how do you know something 100%?
Yeah.
You'd have to see it with your own eyes, right? If you saw this with your own eyes, you wouldn't be on the jury list, you'd be on the witness list.
Sure.
Okay, so the law recognizes that impossibility, and it's beyond a reasonable doubt, meaning using reason and common sense. Is there doubt as to my client's guilt? And if so, it's either because of the lack of evidence or the evidence that was presented just was not sufficient. Okay, so the trial standard is beyond a reasonable doubt. It's not 100%, I'll concede that. And I know the prosecutor would agree with that. But it's high up there. If you're like in a football game, you're close to the end zone. Okay. What is the standard to arrest and charge somebody? People don't know this, right? If I were to ask you what's the trial standard, people would say beyond a reasonable doubt, especially if you watch TV or movies over the past 50 years, right? The standard to charge somebody with a crime, and that's why the judge's instruction said, just because Mr. McCullough has been charged does not mean that he's guilty of the crime, okay? The standard to charge is the same standard to search somebody's house or car.
the same standard to arrest somebody. It's called probable cause. Okay, and even that number is not 51%. There's no number attached to beyond a reasonable doubt. There's no number attached to probable cause. It's objectively looking at things. Is there a reasonable likelihood that a person committed the crime? Okay, so to charge somebody, that's a very low bar. Close to 50%, although there's not a number attached to it. Beyond a reasonable doubt, there's a vast chasm between beyond a reasonable doubt and probable cause to make an arrest or to charge somebody with a crime. Okay, does everybody understand that? Right. Would you agree to pay attention to those different standards as you listen to the evidence today? Yeah. At the age where I need reading glasses, I call it. So the charge, there's one charge here, charge of domestic violence. Every crime under Michigan law is made up of parts called elements. The prosecution has the burden of proving beyond a reasonable doubt. There's two elements to this offense. It has to prove both, okay? If it's not, it's not a majority, it's not 3 out of 4. If the prosecutor doesn't prove each element individually beyond a reasonable doubt, your verdict would be not guilty. Okay, everybody agree to follow the law in that regard. Hold the prosecutor to his burden of proof. Okay, and he's a fine attorney. I'm sure he's proud of the burden that he has. Does everybody understand that Mr. McCullough and I have no burden of proof? He's presumed innocent. He doesn't have to prove his innocence to you. That's the starting point. He and I could do a crossword puzzle during this trial. And if the prosecutor didn't prove each element, even though I didn't do a thing, I'm going to do something. I promise you that. I promise my client that. But if I didn't, and the prosecutor still did not meet his burden, your verdict would be not guilty. Okay. Juror number 6. You talked about a childhood where your parents were abusive to each other growing up. Was there ever police involvement? Do you remember police being at the house? Okay, so no court, you don't know of any charges or court cases? Do you feel, looking back, that you wish that the police had been called or that there was some intervention? Okay. So with that personal experience, is this your opportunity if the case comes in and you're like, I'm not really sure about this, but darn it, my parents should have been held accountable. So I'm gonna, even though the prosecutor didn't meet his burden, you know what? It's a close call. I'm gonna hold Mr. McCullough responsible, just as a way of redemption in your mind for, okay. All right. Juror number 3. Your father was abusive towards your mom when you were a child. Same question. Was there ever any police called to the house?
Not that I recall.
Okay. And was this a systemic thing that occurred over the course of your lifetime as a child?
Yes.
Do you wish that the police or the court system had been involved as you look back?
It was like my dad and my stepmom. They weren't married. Yes, because my dad would have gotten help.
Okay.
But
Do you see this, this jury, if you're chosen as a juror, do you see this as an opportunity for that sort of redemptive act where I can say, you know what, close enough for the prosecutor, I want somebody held accountable for this type of crime. And I don't care that he didn't meet his burden. It's a close call, but I'm gonna find my client guilty simply to get back at the system or to redeem it in your mind.
no.
Okay, all right. Does everybody agree that you will so your role as jurors, if you're chosen, is to be the finder of fact. Okay? You decide what happened on January 4th at this Curtis Avenue address in the city of Lansing, state of Michigan. Okay? You're deciding what occurred. So you decide what the facts are collectively in your deliberations. Her Honor gives you the law that you apply to those facts. It's a formula. You don't get to decide what the crime of domestic violence is. You do get to decide what the facts are that you apply to the law that the judge gives you. Okay? You decide the facts, you apply the law, and then from there comes a just verdict. Okay? When juror number 7, how far along are you in your medical program?
I am about halfway through both medical school and graduate school.
Okay. When somebody says domestic violence or domestic abuse, what sort of actions pop up in your mind about what that means?
Predominantly, I think of assault and battery cases. That's mostly what I've seen, but I do know there are also social isolation, there's emotional, there's financial, there's a bunch of it's multifactorial and complicated.
Oh, I agree 100%. Books are written about it.
Yes.
Medical school classes are devoted to it.
Yes.
To focus on the physicality aspect, when you say assault and battery, you mean punching, slapping, choking?
I was always taught assault and battery is any hands that are unwanted and cause harm.
Okay. Number 6, same question. What kind of actions in your mind do you conjure up? Number 5.
Hopefully the same physical abuse.
Okay. Number 4.
Mostly physical, but also some of the more emotional, like isolation and mental abuse.
Okay. Number 3.
Yeah, hands on you that you.
Number 2.
Physical and also the intent to make someone feel like they're going to be assaulted.
You use the word intent, which is where I was going. You're a mind reader. Okay. I'll come back to that. Number 1.
I would agree, just physical control, intent to force.
Okay. Now, the crime that Mr. McCall has been charged with is a specific intent crime. All right, does everybody so to illustrate what that means, intent is everything about the charge. Okay, there's an action, and then it has to be born from a specific intent to assault or to batter. Okay, that's what's been alleged. Intent is everything. So to illustrate that, number 4, if I took out a gun and I shot at you and you ducked, am I off the hook because of your cat-like reflexes?
No, because you're in.
I'm going to be punished for what I intended to do. All right. Now let's say that we're on so let's say that I was going to walk out that door right there. There's no window. I can't see on the other side of it. And there's somebody standing on the other side of the door waiting to come in. And I do an action. I open the door and I hit that person in the nose and I break that person's nose. Okay, I did not know that that person was on the other side of the door. I caused somebody harm from my action. Should I be criminally liable for a battery because of opening the door? No. Number 7, why not? The intent wasn't there. Okay, so they have to coexist. Does everybody understand that? Everybody agree to apply that law to your reasoning when you're deciding this case? Anybody believe they cannot do that? Raise your hand. Only a few of you raised your hand about being married. Raise your hand if you've been in a relationship of some sort with another person, an intimate relationship with another human being. Okay. Ever get into arguments? Heated arguments?
Say he, no.
Okay. In a marriage, let's say a marriage that's on the rocks, can you contemplate that there might be heated arguments that go along with that sort of tumultuous relationship? Raise your hand if you believe that arguing with your spouse is a crime. I'm seeing no hands. The prosecutor asked you, have you ever known anybody that fabricated a report? I just want to talk about that, because you have to know quite a bit about a number of things before you could say, I believe this person fabricated a police report. Right? You'd have to know the facts of the case, right? And then you'd have to compare it to the report that was made. Right? You have to know an awful lot about the incident to conclude in your own mind that a report was fabricated. Would you all agree to that? Okay, so it's not quite a question of just in general, hypothetically, have you ever known anybody? It's like, have you ever met, has any of your friends and family ever shoplifted a candy bar in their entire life? I think the answer is you don't know unless you happen to know, right? Now, if they had and you just weren't aware of it, you can't say definitively that theft had not occurred. Is that fair? Okay. During a contested, short, bitter, tumultuous marriage, can you contemplate a scenario where one person might lie against the other, especially if there's a child involved in a pending divorce? Can you contemplate that? Does anybody have any friends or family in law enforcement? Number one, you're nodding. Family member or friend?
Family members.
Members, plural?
Yes.
Close family members?
My aunt and uncle.
And are you close to them?
Fairly close, yes.
Are they police officers in Ingham County?
No.
How often do you see them?
Maybe like 5 or 6 times a year.
At family gatherings and whatnot?
Yeah.
Do they talk shop to you? Do they talk about work?
Loosely, not detailed discussion about work.
Are they patrol officers?
They're detectives.
Detectives. Okay, so they were patrol officers and moved up the ranks. Let me ask you this. Next time you get together at a family gathering, all right, you got close family members that are cops. Okay. And you believe that the prosecutor did not meet his burden and you returned a verdict of not guilty. Are you going to be able to face the familial wrath of your aunt and uncle who are like, you're on a criminal jury and you didn't find the defendant guilty? Traitor. Yeah. Will that pressure, I might be exaggerating it a little bit, but it's there. You think you could withstand the scrutiny and stick to your decision and be proud of your decision at the end of the trial, even if it is not guilty? Okay, there's a little hesitation, a little equivocation there. Now and I know that we're a room full of strangers, and it's not easy to bring up things, but we're trying to get a fair trial here. And now is the time to bring that out. And I applaud you for your candor. But it's not after the trial when you're back in the deliberation room saying, well, how am I going to face my aunt and uncle? So honestly, do you believe that that's a concern as you sit here today?
I don't think it's a concern with them. that wouldn't affect my decisions or views or thoughts today.
Okay. Let's say that this is the jury, and you go back and you deliberate, and you believe that the prosecutor did not meet his burden. And all the other 6 are like, yes, he did. Are you a strong enough personality, aunt and uncle aside, are you a strong enough personality to say, because every verdict has to be your own. It's got to be a unanimous verdict, but every verdict has to be the honest belief in each of your hearts and minds. Okay. Could you stand up to 6 others and say, I believe it's not guilty. That's my decision. We've talked about it. We've grappled with it. We've struggled. I believe there's reasonable doubt. Are you a strong enough personality to do that?
I think I'm strong enough to state my thought, but I don't know that I'm strong enough to debate in order to change other people's minds.
Okay, that makes perfect sense. All right, thank you. Number 2, same question. If you have a strongly held belief about guilty or not guilty, and it's at odds with other members of the jury, obviously deliberate and grapple with the facts, but at the end, if it's your own decision, are you able to stick to it? Or do you, I don't like to use the word cave, but you know, it's 4:30, kids got a recital tonight or a swim meet, and it's 6 against 1. All right, you know what, I told.
I'm not sure that wouldn't be the case.
You're not sure that what wouldn't be the case?
That I wouldn't, feel peer pressure to go with the rest of the group.
I appreciate your honesty there. All right, do you think that that's fair?
And if I was the only one that thought he was guilty and everybody else thought he was innocent, I'm not sure that I wouldn't cave. Or even if I was the only one that thought he was innocent, everybody else, I'm still not sure I wouldn't cave. I just tell him put in that position. I can't be honest which way I would go on that.
Right, I appreciate that. Number 3.
No, I would stick to what I believe in.
Number 4.
I think I'd probably stick with what I believe.
5.
I would stick with what I believe in, but I don't think, like Mr. One said, that I wouldn't be a debater about it. I'm not that.
Okay, all right, but you'd be paying attention to the trial.
Oh, yeah.
And you would participate in the deliberations.
Yeah.
And you would express your honest felt beliefs.
Yeah.
Number 6. Sometimes it gets pretty heated back there. We're talking about domestic violence situations. It's kind of like a steel, it should be like an octagon back there sometimes. It's like a steel cage. I don't want to stay there, but number 7.
I'd stick to my beliefs and was provided sufficient evidence otherwise.
Just a couple more questions. Does anybody feel like they're sitting in judgment of another person by sitting on a jury? What I mean by that is, do you believe that are you here to decide whether Mr. McCullough is a good person or a bad person? Okay. All right. And the people that are nodding, you're correct. Or shaking your head no, in the negative, you're correct. You're not sitting in judgment. There's only one judge in the room, and that's her honor. You're analyzing a tiny slice in time, basically 5 minutes on January 4th at about 2 p.m. on Curtis Avenue. You're looking at a tiny slice in time, and you're deciding whether or not the act that's been alleged by the prosecutor was intentionally committed by my client. Okay. If the prosecutor, I'll say this, if the prosecutor proves every element beyond a reasonable doubt, what would your verdict be?
Without a reasonable doubt, then it's guilty.
Okay, so you, and nobody would have a problem voting guilty if the prosecutor meets his burden. If the prosecutor does not meet his burden, is there anybody here, for any reason we haven't discussed, is there anybody here that could not return a not guilty verdict for whatever reason? Prosecutor doesn't meet his burden as to both elements. What would your verdict be?
Not guilty.
Number one? Number two? Number three? Number four?
Not guilty.
Number five? Number six? Number seven? Thank you very much for your time.
Challenges for cause.
No challenges for cause for the people, Your Honor.
No challenges for cause.
Any pre-emptory.
Yes, Your Honor, people will thank and excuse juror number 2.
Thank you, juror number 2, you may be excused. Any further cause at this time? I mean, preemptories at this time?
Not at this time, Your Honor, thank you.
The challenge, preemptory challenges, Mr. Babe.
Defense would thank and excuse juror number 6.
Thank you, juror number 6. We replace juror number 2 with Garrett Broski. Juror number 6 is going to be replaced with Ann Copper-Ferry.
And
You can bother there's a new juror.
Okay, new juror 2 and new juror 6. Hot in here?
It's gonna get harder than that.
We have to wear our fancy outfits. Ugh. The judge could probably wear shorts and t-shirt underneath his robe, no one would know. Okay. Gonna get right into it. Juror number 2, do you have any experience with domestic violence? No. I don't know if you know anyone who has encountered domestic violence.
Friends when I was younger, hearing about it after the fact, and I was a child.
So this friend, you were a child when you knew the friend? How old when you say child?
5, 6, 7.
Okay, and was this person a friend when you were 5, 6, 7, or are they a friend now? And can you tell me a little bit about the domestic violence involving your friend?
Just that there was some, I don't know, I didn't get too deep into it. I thought that about from my mom after that. As I was older.
Was the friend about your age? So was your friend was it a childhood situation?
Another, I believe it was the dad using the child. Some extent.
Okay, so dad was a abuse. Okay. So you heard about it. And I guess sitting here now, do you have any sort of preconceived notions or just any kind of thoughts about domestic violence in general?
It's not good.
It's not good when it happens. I think we'll all agree on that.
But yeah, no.
Okay. Juror number 6. Do you have any experience with domestic violence?
No.
You know
Sheltered
anyone?
life.
What's that?
I lived a sheltered life.
Live this sheltered
As far
life.
as I can.
Okay. What makes you say you live this sheltered life?
I have no experience with any kind of violence at all.
That's kind of.
Shelter.
That's the, you say it like it's a bad thing. That sounds like, it sounds like the people around you have done right by you. It sounds like that's something that should. Saying you like it's a bad thing, it sounds like a very good thing. That's great to hear. Have you had, friends who've told you stories about No?
No, I'm telling you.
Okay, I believe you. I believe you. Okay. Now back to juror number 2. Actually, 2 and 6, have either of you ever been married? You are married? Is current spouse the only spouse you have? Yes. Okay. Do you have any friends, loved ones who've been through divorce?
Yeah.
Were they amicable divorces? Have you been around contentious divorces?
No, they're pretty much.
Okay. And do you have any thoughts now on whether the family court divorce system sort of slants towards men or women, wives, husbands?
At this point, I don't know. I know when my brother got divorced, they definitely sided more with his wife. So that was
So when did that happen?
very long time.
Very long time ago. So is that something that's sort of?
Oh, more than 40 years.
Okay, so it's not.
It
Sounds
could be
like
way
you don't
different
really,
now.
you don't really know today if that's still the case. Back to juror 2. Do you know anyone who has filed a false, completely fabricated police report? Juror 6, what about you? Now, juror number 6, we'll start with you this time. Do you think that you're able at all to sort of tell if someone's telling the truth, someone's lying?
I would need to, pay attention,
Yeah.
study, and make sure, that the only thing that looks.
So body language is something that
Body
you
language.
look for when determining if one person's telling the truth rather than another person.
It's a big factor.
Okay. And do you think that when you have 2 people giving different versions of what happened, do you think you'd be able to say with conviction that one of them is telling the truth, or do you think you'd be kind of hesitant to?
No, I'm not. This one's been telling the truth.
And how do you feel about your ability to read body language for someone who you've never met before?
Probably.
What sort of body language
Like-
suggests?
Oh, see, that's, I'm watching a lot of TV.
You watch a lot of TV.
They don't look at you directly. They avoid eye contact. They look off, to the right or left, whatever. They don't face you right on and tell you the truth.
Okay.
It may not be the truth.
Is
I mean,
that,
it could be
yeah. Is that something that could also be explained though by
shyness, I know.
what?
Shyness.
Shyness, yeah, so you can see
Yeah,
there's
it could
other
be.
ways too.
Yeah, it could be, but I mean, you have to take the plausibility of it. too.
So if someone is looking in the eyes while they're saying with their chest, you're gonna be more likely to believe them.
Looking in the eye.
You know the expression
Stare me
saying with your
down?
chest?
No, I never heard that. Told you. If they stared at me, I'd have a little worry about what they were telling me.
Okay.
And normal eye contact. That's just looking at you and talking. Looking at you and talking. Making sure my eyes don't move, that's signal to me. That's it.
Okay. And juror number 2. When you've got 2 people telling confused stories, do you think that you feel equipped to sort out who's telling the truth?
Facts and then kind of look at your relationship and really don't know either person, you kind of just have to go on their behavior, the story.
So when you say the story, like whether the story makes sense?
The sense of it all.
When you say you look at the
facts,
facts, what are the facts?
I don't know.
So, you'll have someone testifying XYZ happened. When you say the facts, you're referring to something other than their testimony?
Like if something can't happen or whatever, they're like, the stories aren't adding up, I guess, with certain facts. Or how things occur. Happen, so you kind of take your best guess.
To sort of examining what outside of what people are telling us and kind of what in line with.
And what they're all saying this thing, and then how that differs, and kind of have to just take those differences. With what, that's it.
That's all my questions.
Number 6, how long have you been married?
Almost 18 years.
Okay. All right. You have kids? No kids. Number 2, not married. Do you have any children? Okay. I'm coming up on 35 years myself. I'm beginning to think it's going to work out.
I think you'll be okay.
Neither of you have kids. So I was going to say is, you come home and you got 2 kids and the lamp is broken. And the kids are going to be like this. Right?
That's how it works.
That's how it works, right?
Yeah, so we did.
Someone's got to be punished for the lamp, right? If you honestly don't know after your inquiry who broke the lamp, do you pick one that pisses you off the most, or that had done something wrong the week before? Or do you punish both of them? Or do you, if you don't know, you don't impose a punishment? Okay, number 2, do you agree with that?
What did she say?
She said if she doesn't know who actually did it, if it's her honest belief that she doesn't know who did it, she's not going to punish either because it might not be fair.
I generally agree to that, but sometimes punishing them slightly may, bring results, I guess. I don't know. I'm not dad, so I have no idea.
Okay. I don't know if you would actually have said that if you were there, but I'll table that for now. Any of the other, you guys were present in the courtroom during my initial questioning, so I'm not going to belabor the point. But any questions I asked as you're sitting there where you're like, I do have friends and family in law enforcement, or I do, are you appear to be a woman of conviction?
Oh, yeah.
Not in the sense that the prosecutor hopes, but
No.
okay, but stick to your guns type of it. Okay, number 2. Okay, and if it's your honest belief after you deliberate, you stick to your guns and what you truly believe is the right verdict.
Yeah, I truly believe that, yeah.
Okay. You heard my questioning about intent. With I shoot at you and you duck, kind of like the Matrix or the bullet goes back. But I miss, I didn't cause you any harm. Should I be punished for trying to kill you? I open up a door, you're on the other side of the door. I open it up and I honestly didn't know you were there and I hurt you. Okay. So an accident. The harm that I caused you with my action was incidental to me opening the door. That's what I tried to do. Okay, do you agree that there shouldn't be a punishment criminally for me? Okay. All right. I have no further questions.
Challenges to cause.
No challenges for cause, Your Honor.
Mr. Favor, any challenges for cause at this time?
No, Your Honor.
Any preemptory?
Yes, if people would think an excuse, juror number 6.
Juror number 6, thank you. You may be excused. Mr. Favor, any challenges for preemptory?
No peremptory challenges, Your Honor.
I'm gonna replace juror number 6. Angela Evans. Proceed, Counsel.
All right, welcome to hot seat. Only one who hasn't giving us anything yet. Just obviously you've been here for a while. It's very hot in here. Do you have anything right off the jump that you want to share that you've got thoughts on?
That would depend on what you need to know about me. I have lots of thoughts.
Yeah, lots of thoughts. We'll just get right into it then. First off, I have to ask, I see that you're a female ranger.
Yes.
Tell me about that. I'm fascinated
I am every day involved in a number of cases that could be domestic, accidental, or natural. And I have to help families navigate through that journey to say goodbye.
Sounds ridiculously hard.
Intense.
Yeah. I don't know how you do it, but it's good that someone is.
Likewise.
So anyway, domestic violence. Do you have any experience with domestic violence?
Not domestic violence, no, but violence, yes.
Tell me about your experience with violence.
My sister was attacked, moved to a secondary location, and raped both vaginally and anally in forced relations.
That's horrible.
Yes.
I'm sorry that you share this with strangers that you can experience that. I'm really sorry about the follow-up question I have to ask. How will that affect you being a juror?
Well, that's a great question because I never know how I would react until my sister was attacked. Someone's actions against another person should always reflect how they feel. So if he felt he had to do that for him, then that's something he has to deal with, and then I have to deal with the outcome of what his actions, regardless of whether he meant to do it, needed to do it, felt compelled to do it, mistakenly did it. There's still fallout from that. So I would say that hearing that someone that may have been smaller felt intimidated enough to say that someone hurt them, I probably would default to that probably did happen. So
Do you have space though for the fact that toxic didn't happen?
absolutely, because as the defense said, intent is different than accident. But because I have been in a situation where someone I love dearly has been injured, and then the trial where she was dragged through the mud when she did no wrong, that's hard. That's the part that would be hard for me.
Hard how?
Because I wasn't there. Okay. So I don't know exactly what happened, but the thought of getting someone into such trouble on this level to justify just because I'm mad at you seems ridiculous to me. To take it that far to cover, if that was, if an intent to do something was taken and escalated erroneously, incorrectly, or fabricated, then to me, I can't understand that. So I would think, why would a person do that? That would be my first thought. And it might not be, was this an intent to hurt this person? It would be like, why did that person feel that they needed
Why did they feel
to say, hey, somebody hurt me? Like, why is that?
And I guess the $1 question is, are you willing to have an open mind?
Oh, absolutely. I'm a very open-minded person.
Are you
Absolutely.
capable of coming back and saying we're not guilty?
Yeah, if he's not guilty, yes, absolutely.
So you need to be persuaded by evidence. That
Yes,
he's guilty.
absolutely.
Okay. Thank you for sharing your, I guess, background. It's very helpful. Thank you for being willing to have an open mind and do your best to isolate those biases. Now, I think that talking that out has kind of answered a lot of my other questions, but I will say just in general, not necessarily in context. When you have two people giving different versions of something, do you think that you have a sense of how to navigate who might be telling the truth?
Work in a funeral home, and when people die, they leave money for life insurance policies. And people constantly are after that money, rather than making sure that their loved one gets cremated if they should. I literally see that every day. I don't know. I just don't know. I would like to believe that if you're in a court of law, you're telling the truth. But I don't know. Human nature can be tricky.
Do you think that money is something that motivates people to lie?
No, that's not the only thing. But money is, it's definitely a piece of it, because in the long term, everything can come back to money or your family if you look hard enough. Like, for instance, we're here at this court hearing today. Somebody is losing out on time at their job, so that's a loss of money. So that can be a deciding factor of why you're defending against yourself. Or if that person got injured and she has to prove that like that person hurt her, even if that person didn't hurt her, because she's gonna lose out on money or respect from people, you know, like there's like a lot of factors, and I truly believe you have to have the evidence.
All right, thank you. That's all the
Yep.
questions I've got.
Your answers to the prosecutor answered a lot of the questions that I was going to ask. I'm sorry about what happened to your sister.
Thank you.
You don't discount the possibility that just because somebody takes an oath and takes the witness stand that they're telling the truth.
That's like the, yes, I believe that.
So you agree that not everybody that testifies is testifying 100% truthfully.
That is true.
Otherwise, there wouldn't be a perjury charge, correct?
True.
It wouldn't exist because everybody's telling the truth. If you hear, do you have children?
I do have 4 children.
So you're an expert witness on what I'm about to talk about right now. Your ability to get to the truth when there's a dispute, you get 2 different versions, maybe 4 different versions of events. You go through a logical process to try to decide what happened, right? Somebody took cookies out of the cookie jar. You're going to look for the kid that's got maybe crumbs on their shirt collar or something, even if they're denying, right?
Or were they hungry?
Oh.
Did they not get a snack at school?
Well, let's say that you forbade them from, I just chose that at random, but let's say you forbade them from doing something and they did it.
Okay.
Okay, I'm not talking about Jean Valjean with the loaf of bread, okay? There's a justification for everything, probably. If you honestly don't know which of the 2 is telling the truth, there's reasonable doubt about what actually happened. Would you impose a punishment?
If someone does something wrong, punishment should be imposed.
Yes.
Regardless of what that is, in our severity level. Like, is it you don't get dessert when everyone else gets one because you took that dessert now? Because that's why you couldn't have it? Or was it because you didn't need it anymore and you took it because you're being gluttonous? That's a story. I have to have the evidence for that. I can't just make a decision based on it. You're both telling me you didn't do it and no one did it. And then we come to find out that your other sister actually did it. Who is at blame if I make a decision and punish those 2?
Like, yeah, exactly. So if there's reasonable doubt about what the truth is, do you think that a punishment is fair?
Well, that's the question I have. Was there a punishment in the first place? Like, was the action that took place so awful that it deserves a punishment on both halves, or on one half, or on no halves?
Would you just base it on the severity of what happened, or would you follow the evidence and
I would
say,
follow the evidence, like,
okay,
you know,
so if it's your honest belief at the end of the day that you don't know which version of events is correct, would you take action in terms of, I mean, you have to punish the person that committed the crime, right?
right? But wouldn't that be me saying I can't make a decision based on the evidence that was given?
Well,
If the
if
burden of proof was not met.
exactly. Do you agree with that?
Yes.
Thank you.
Challenges for cause.
No challenges for cause, Your Honor.
And for you.
None for cause, Your Honor.
23 and 3.
No, Your Honor.
23 and 3 for you.
Thank and excuse juror number 6.
And number 6, you may be excused. Thank you. Thank you. Edward Lyle. Six is the hot seat today.
They're all hot seats today.
Well, they'll all be hot seats in a minute. When that, it's not that bad right now.
I know.
And this is the wool roll.
You also have a thermometer?
No, but I can tell you right now, we haven't even turned that fan on yet. So this is not even, we've not begun to fight in here.
Oh. Exciting. Okay. We do usually have a revolving door seat, and it's seat 6 today. Wait another day.
Good.
Just jump right into. Do you have any experience with domestic violence?
My daughter.
Your daughter was
With her husband.
Okay. Was her husband abusing her?
It was a physical confrontation.
Was it a one-off?
One time, yep.
One time, and the physical confrontation, can you just sort of tell me a little bit about what you know?
I wasn't there, but just, I got my daughter's version that they got in a physical fight. But she was the one that was arrested.
Okay. So, what do you think of the fact that she's the one who was arrested?
Because I know the relationship in the past, so it's not the first time well, I guess it's not the first time that they've had a fight. So, but I don't know. I just was on my daughter's side, believe it or not.
And what has that sort of informed, I guess, your opinions in general on domestic violence? Has it
No, not really, because I don't think you should put your hands on it.
Yeah. I think most people agree with that. Now, do you know anyone who has ever filed a false police report? No. Fabrication? No. Are you currently married?
Yes.
And are you on spouse number 1? Or have you been?
No. I've been married twice before.
Okay. Your previous, those marriages ended in divorce?
Yes.
And were those contentious or were they pretty good?
The first one was amicable, the second one was a fight.
Okay, what did you guys find?
Just property.
And how did you feel about the ultimate resolution of this thing?
I was glad it was over.
Just glad it was over.
Yeah.
Did it leave you feeling, either of your divorces, they leave you feeling any type of way about whether the system favors husband or wife?
When I got divorced the first time, yes.
What about the second time?
Nah, that's not good.
Did it leave you feeling like in general the system favors the wife?
The first divorce did, yes.
Okay. But the first divorce, I mean, like in general.
In general,
does
yes.
the system in general big picture favor the wife?
Correct.
Okay, gotcha. Now, when you have two people giving competing versions, different versions of something that happened, do you think you have a good sense of how to tell who might be telling the truth, who might be lying?
Yeah, I'd have to go through the facts,
Okay.
First. And plus their mannerisms, and how far, if one person sticks to their story or the other one person's story is all over it, you know what I mean? So.
Okay, so consistency is something you look for.
Sure.
And when you say body language, what kind of body language?
Just how they're talking, how they're reacting, if they're looking away, not looking at you.
Okay. And when you have two people giving different versions, do you feel as though you're capable of saying with conviction, no pun intended, this person is telling the truth, this person is lying?
Yeah,
you can get there.
I could probably get there.
Okay. I think that's all the questions I have.
Okay.
Great.
Number 6, how you doing?
Good.
You heard all of my questions. Is there anything that you believe you should bring to my attention to be just to ensure as best as humanly possible a fair jury?
Well, I was kind of in law enforcement. I'm a retired correctional officer for the state of Michigan.
Okay. All right. Did you ever do road patrol? Ever respond to domestic violence calls?
Just inside.
Okay, all right. So you probably heard stories from people that were in custody for domestic violence.
Correct.
Right. Would you promise any personal stories or any personal experience that you've had talking to other people? Would you agree that that has no bearing on this particular case?
Correct.
Okay, and you put all that aside and focus your verdict on the evidence as
Sure.
it's presented here.
Yes.
Thank you. Nothing further.
Challenges for cross.
No challenges for trial, Your Honor.
Same thing.
No peremptory challenges, Your Honor.
The defense is satisfied with this jury. Your Honor.
Ladies and gentlemen, we do have a jury. The rest of you all. No. Didn't make it this time, but, and I know, Mr. Manager, you are very tore up about that. I'm sure there'll be other opportunities in the future, maybe not this week, because I don't think we're holding any jury trials here after today in this court. But thank you for appearing and being so willing and eager to participate in this process. Again, this process doesn't work unless we have willing participants from the public. So we're going to excuse you all. The remaining of you all will get stickers to identify yourself as jurors. We're right at the top of the hour, so I need to give you a break for lunch. And so I am going to give you until, let's come back at 1:35. Let me give you about 40 minutes. There's a room back here, the jury room. There's a restroom there. That room is closed off and only the jurors are allowed to be in that room. So you're welcome to stay in there and eat your lunch. Of course, there's a few restaurants out there. Because I'm not going to go over the next set of jury instructions now, I am going to tell you that you're not allowed to talk to any of the lawyers or anyone that's connected to this case. And you don't know who's connected to this case. So you have to be very cautious when you're in the hallways or on the elevators to make sure you're not, or if you use the restroom downstairs, to ensure that you're not having communications with someone that may be connected to this case. If while you're out, someone does speak to you, or they're speaking to you about the case, you tell them to stop, you let them know you're a juror if they can't see your sticker, and then you'll report it to my staff as soon as you return. Again, you can't speak to them even if it has nothing to do with the case. So if you see Mr. Faber in the elevator, you can't say, wow, it's getting light out, or you can't do that. Because it could give the appearance of impropriety. So I wanted to advise you of that. We'll go over your next set of jury instructions when you return, and then the lawyers will be able to do their opening statements and proofs, okay? So again, be back here at 1:35. All rise for the jury. You can be excused.